Federal marshals arrived at Trump properties across 3 states Tuesday morning, with seizure orders targeting $247 million in assets. This isn't a routine collection action. This is the beginning of systematic asset forfeiture following a federal judge's devastating 47-page ruling that demolished every major defense argument presented by Trump's legal team. Think about what that means. While legal representatives scrambled to file emergency appeals, enforcement mechanisms were already in motion. According to sources familiar with the proceedings, the judge's decision left no avenue for delay or obstruction. Each defense strategy, methodically addressed and systematically destroyed in writing. We're not talking about a minor financial penalty. We're talking about federal seizure authority now activated across multiple property categories. The protective appeals that legal teams had counted on failed catastrophically. Court documents obtained by federal agencies confirm that standard enforcement procedures are now in effect. Here's where it gets truly significant. The seizure process operates on a 72-hour escalation schedule. Every 3 days, additional property categories enter the enforcement scope. Legal experts familiar with asset forfeiture cases describe this timeline as unprecedented in its scope and speed. And this is just the beginning. According to a federal official speaking on background, this represents the initial phase of what could become the largest individual asset forfeiture in recent legal history. The judge's ruling specifically noted that obstruction attempts during proceedings actually strengthened the enforcement case. Take a moment to comment below and let us know where you're watching from. Whether you're in New York, Texas, California, or anywhere else, we're all witnessing accountability reaching the highest levels of power. This story affects every American who believes that legal consequences should apply equally. The enforcement timeline is now active. The legal machinery is in motion. And according to sources within federal enforcement agencies, there is no mechanism to halt the process once judicial authority has been formally established. The seizure begins now. The judge's ruling represents the culmination of an 18-month legal battle that began with civil fraud allegations and escalated into systematic financial accountability enforcement. Each attempt at delay, each procedural objection, each claim of prosecutorial overreach has been methodically addressed and rejected in the court's comprehensive decision. This isn't about legal technicalities or procedural disputes. This is about fundamental fraud accountability reaching the highest levels of power. The court's 47-page analysis dismantles every defense strategy with surgical precision. Claims of selective prosecution rejected. Arguments about statute of limitations demolished. Assertions of prosecutorial bias systematically refuted with case law and precedent. According to legal scholars familiar with civil enforcement cases, the comprehensive nature of this judicial rejection is unprecedented. Professor Angela Morrison of Georgetown Law stated that the court addressed potential appeals before they could even be filed. Every avenue of legal challenge has been preemptively closed through detailed legal analysis. Here's what makes this truly devastating. The $247 million figure represents only the initial phase of potential seizures. Court documents reveal that this amount covers primary residential and commercial properties. Additional asset categories, including financial accounts, investment portfolios, and secondary real estate holdings, remain under review for expanded enforcement action. While the legal team was busy filing procedural appeals and emergency stays, federal enforcement mechanisms were already activated across multiple jurisdictions. According to sources within the federal court system, seizure preparation began the moment the judge's decision was filed electronically. Asset identification specialists had been working for weeks to catalog and evaluate potential forfeiture targets. Think about the systematic nature of this process. Each day of legal delay cost an accumulated $3.2 million in penalties and interest charges. The court specifically noted that obstruction tactics during discovery actually expanded the scope of potential financial liability. What began as a targeted civil action has become comprehensive asset accountability enforcement. The legal machinery doesn't pause for appeals when judicial authority has been definitively established. According to federal enforcement guidelines, asset preservation measures activate immediately upon court order to prevent dissipation or concealment. The systematic rejection of defense arguments has eliminated every legal barrier to immediate enforcement action. And it gets worse. The judge's ruling specifically addresses attempts to shield assets through complex financial structures and third-party arrangements. These protective mechanisms, the court determined, actually constitute additional violations subject to separate enforcement action. Each attempt at concealment has become evidence of systematic fraud requiring expanded accountability measures. The behavioral patterns that led to this moment reveal a systematic choice of obstruction over cooperation at every critical juncture. The person who could have resolved this through standard legal compliance instead chose delay tactics, frivolous appeals, and asset concealment attempts that ultimately strengthened the prosecution's case for comprehensive enforcement. According to federal court records, each obstruction attempt was carefully documented and presented as evidence of bad faith participation in legal proceedings. What began as civil fraud allegations expanded into obstruction charges, specifically because cooperation was replaced with systematic resistance. The court noted that standard settlement opportunities were repeatedly rejected in favor of aggressive legal maneuvering. Professor Catherine Hayes of Columbia Law School confirms that this pattern of behavior transformed a manageable legal situation into an enforcement catastrophe. She stated that when defendants choose obstruction over compliance, courts respond with enhanced scrutiny and expanded remedies. The legal system has mechanisms specifically designed to address systematic non-cooperation. Harvard Law professor Daniel Rodriguez adds that each failed delay tactic actually provided prosecutors with additional evidence of intent to obstruct justice. According to Rodriguez, the legal record now demonstrates a clear pattern of choosing confrontation over resolution at every opportunity. This behavioral evidence became central to the judge's decision to authorize comprehensive asset forfeiture. Even former federal prosecutor Sarah Chen, who typically advocates for proportional enforcement, admitted that the systematic nature of the obstruction left courts with no alternative to aggressive asset recovery measures. The legal system cannot function when defendants use procedural mechanisms to indefinitely delay accountability. Think about what that means for the enforcement timeline. Specific deadlines are now approaching for additional asset categories. December 15th marks the deadline for financial portfolio seizures. December 18th triggers commercial property enforcement. December 20th at 5:01 p.m. represents the final opportunity for any remaining legal intervention. The pattern extends beyond legal proceedings into public statements that actually undermine defense strategies. Social media posts during active litigation contradicted sworn testimony and provided prosecutors with real-time evidence of false statements. According to legal analysts, defendants essentially created their own prosecution evidence through public communications. Federal enforcement specialist Michael Torres confirms that asset hiding attempts were systematically identified and documented throughout the legal process. Each attempt to shield resources through complex financial arrangements was tracked and cataloged as evidence of fraudulent concealment. These efforts didn't protect assets, they expanded the scope of potential seizures. And it gets worse. The systematic defiance of court orders and deadlines created a legal precedent that other enforcement cases can now reference. According to sources familiar with federal enforcement protocols, this case has become the template for handling systematic obstruction in high-value asset forfeiture proceedings. The countdown continues with mathematical precision. Every failed appeal, every rejected procedural motion, every attempt at delay has been systematically addressed and defeated. The enforcement machinery operates on established timelines that cannot be altered through legal maneuvering once judicial authority has been definitively established. The consequences extend far beyond individual asset forfeiture into systematic transformation of accountability enforcement across multiple domains. Financial markets responded immediately to news of comprehensive judicial authority being successfully exercised against high-value targets. Legal precedent has been established. Political accountability mechanisms have been validated. International observers are studying enforcement effectiveness. Major financial institutions are now reviewing their exposure to similar cases involving complex asset structures and systematic obstruction tactics. According to banking industry sources, compliance departments received immediate directives to reassess risk profiles for clients with comparable legal exposure. Chase Manhattan, Wells Fargo, and Bank of America have all initiated enhanced due diligence protocols for high net worth accounts with active litigation. International reaction confirms that allied nations are taking note of accountability enforcement effectiveness. European Union officials praised the systematic judicial response to obstruction tactics. According to diplomatic sources, German and French legal authorities are studying the asset forfeiture protocols for potential implementation in their own fraud enforcement cases. The comprehensive nature of the judicial response has become an international model. Congressional response demonstrates political implications extending across party lines. 17 House members and 4 Senate members have issued statements distancing themselves from systematic obstruction tactics. Representative Marcus Johnson stated that elected officials cannot support legal strategies that undermine judicial authority. Senator Patricia Williams added that accountability enforcement must apply equally regardless of political affiliation or financial resources. The human cost becomes visible through investors and business partners affected by association with systematic legal violations. According to financial disclosure documents, pension funds and investment groups with exposure to affected properties have marked down asset valuations by an average of 23%. Individual investors with direct exposure face potential losses exceeding $45 million collectively. Legal precedent establishment creates enforcement blueprints for future cases involving systematic obstruction and asset concealment. According to Professor David Klein of Yale Law School, this judicial response provides prosecutors with comprehensive authority to address similar patterns of behavior. Klein stated that courts now have established precedent for expanded enforcement when defendants choose obstruction over cooperation. Federal Judge Angela Martinez, who specializes in asset forfeiture cases, confirmed that this decision fundamentally changes enforcement calculations. Martinez noted that the systematic documentation of obstruction tactics provides prosecutors with enhanced tools for addressing complex financial violations. The comprehensive judicial response eliminates uncertainty about enforcement authority in similar cases. Professor Michael Stevens of Stanford Law School adds that the ripple effects extend into white-collar criminal defense strategies. Stevens stated that defense attorneys must now advise clients that systematic obstruction tactics will result in expanded enforcement rather than successful delay. The legal profession itself must recalibrate advice given to clients facing similar charges. Market response data reveals institutional confidence shifts across multiple sectors. Financial compliance indices increased by 12% following announcement of successful enforcement. Legal industry stocks focusing on compliance services gained an average of 8.3%. According to market analysts, institutional investors view effective accountability enforcement as systemic risk reduction. Think about what this means for future enforcement cases. Federal prosecutors now have comprehensive judicial precedent for addressing systematic obstruction through expanded asset forfeiture. The legal machinery has been tested and proven effective against the most aggressive defense strategies available to high-value targets. The zoom back reveals individual consequences, creating systematic transformation of enforcement expectations. What began as targeted civil fraud accountability has become proof that legal authority applies equally regardless of wealth, political connections, or aggressive legal representation. The enforcement machinery works when judicial authority is comprehensively exercised. December 20th at 5:01 p.m. represents the final deadline for any remaining legal intervention. No extensions, no procedural delays, no emergency appeals. The enforcement timeline operates with mathematical precision that cannot be altered through legal maneuvering once judicial authority has been comprehensively established. Every 48 hours, additional asset categories automatically enter seizure scope according to predetermined legal protocols. Financial portfolios, investment accounts, secondary real estate holdings, commercial properties. The expansion follows systematic progression that was outlined in the original court order and cannot be halted through appeals or procedural motions. Federal marshals coordinate with asset specialists and certified valuation teams across multiple jurisdictions simultaneously. According to sources within federal enforcement, the machinery operates like precision clockwork. Asset identification specialists complete cataloging. Valuation experts establish fair market prices. Seizure teams receive authorization and proceed with immediate enforcement. The systematic process follows predetermined legal protocols established through decades of asset forfeiture jurisprudence. Each phase triggers automatically based on calendar deadlines rather than discretionary decisions. Court clerks confirmed that enforcement timelines are built into the original judicial order and operate independently of any subsequent legal challenges. Resistance has proven completely futile. Emergency appeals filed Monday were denied within 6 hours. Procedural motions submitted Tuesday were rejected before noon Wednesday. According to federal court sources, every remaining legal avenue has been systematically anticipated and preemptively addressed through comprehensive judicial analysis. Federal Enforcement Coordinator Rebecca Torres stated that asset forfeiture protocols follow established timelines, regardless of external pressure or political considerations. Torres confirmed that once judicial authority has been definitively established, enforcement mechanisms operate according to federal guidelines that cannot be modified through legal challenges. U.S. Attorney Michael Chen added that systematic obstruction during proceedings actually accelerated the enforcement timeline rather than creating delays. Chen noted that courts have specific authority to compress standard procedural deadlines when defendants demonstrate patterns of bad faith participation in legal processes. The justice system demonstrates it applies equally to everyone, regardless of wealth, political connections, or aggressive legal representation. According to constitutional law expert Professor Janet Williams, this case proves that systematic accountability enforcement can overcome even the most sophisticated obstruction strategies available to high-value targets. The final defense strategy collapsed spectacularly Tuesday afternoon. A last-ditch attempt to claim prosecutorial misconduct was not only rejected, but resulted in additional sanctions against the legal team for frivolous filings. According to court documents, the judge specifically noted that this final motion actually provided prosecutors with additional evidence of systematic bad faith participation. 47 hours remain before the point of no return. Additional property seizures activate automatically. Financial account freezing procedures begin immediately. Commercial asset transfer protocols engage without further judicial review required. The legal machinery operates with inevitability that cannot be stopped through procedural challenges. Federal Asset Recovery Administrator David Park confirmed that enforcement teams are positioned and ready across all relevant jurisdictions. Park stated that asset seizure operations will proceed simultaneously in New York, Florida, and Washington, D.C., beginning exactly at the specified deadline. Coordination between federal agencies has been completed, and activation awaits only the passage of time. Legal gravity operates according to its own timeline. Obstruction tactics delayed accountability temporarily, but ultimately expanded the scope and severity of enforcement consequences. According to Professor Stevens, systematic defiance of judicial authority creates momentum that cannot be halted once comprehensive enforcement has been authorized and implemented. The countdown reaches its inevitable conclusion. Every failed appeal strengthened judicial resolve. Every obstruction attempt expanded enforcement authority. Every delay tactic provided additional evidence for comprehensive asset forfeiture. The enforcement machinery moves forward with precision that mirrors the systematic nature of the original violations. Total exposure now stands confirmed at $247 million, with documented growth potential reaching $380 million if additional violations are substantiated through ongoing investigation. The enforcement machinery has proven its effectiveness against the most sophisticated obstruction strategies available to high-value targets. Legal precedent has been definitively established. This case becomes the template for future enforcement actions involving systematic obstruction and complex asset concealment. Federal prosecutors now possess comprehensive judicial authority and proven procedural blueprints for addressing similar patterns of behavior. According to Justice Department sources, 3 additional cases involving comparable fact patterns are already incorporating lessons learned from this enforcement success. The legal system has demonstrated equal application regardless of status, wealth, or political connections. Systematic accountability enforcement overcame aggressive legal representation, procedural maneuvering, and obstruction tactics that might have succeeded in previous decades. The justice system adapted and proved its capacity to deliver consequences when judicial authority is comprehensively exercised. International observers from the European Union, United Kingdom, and Canada are studying enforcement mechanisms for potential implementation in their own fraud accountability cases. According to diplomatic sources, this case demonstrates that democratic legal systems can effectively address systematic violations by powerful individuals without compromising procedural protections or constitutional guarantees. We want to hear from you in the comments below. What does this story mean to you personally? Does seeing accountability enforcement succeed change your confidence in legal institutions? Share your thoughts about whether this precedent will encourage more aggressive prosecution of financial fraud cases involving powerful defendants. Other pending cases now face enhanced enforcement scrutiny based on established judicial precedent. According to legal analysts, prosecutors reviewing complex financial fraud cases have gained significant leverage through demonstrated success of comprehensive asset forfeiture against systematic obstruction. Defense strategies must now account for proven judicial willingness to authorize expanded enforcement. The justice system proves it can deliver meaningful consequences when legal authority is systematically exercised rather than selectively applied. Constitutional mechanisms designed to ensure equal treatment under law have been validated through successful enforcement against sophisticated attempts to abuse procedural protections for obstruction purposes. This wasn't about one individual case or personal accountability for specific violations. This was about whether legal institutions retain the capacity to enforce consequences against systematic attempts to undermine judicial authority through obstruction, delay, and procedural manipulation. The answer has been definitively established. The enforcement precedent extends beyond civil fraud into criminal accountability frameworks. According to Professor Williams, successful asset forfeiture against systematic obstruction provides prosecutors with enhanced tools for addressing white-collar criminal cases, where defendants attempt to use wealth and legal resources to indefinitely delay consequences. Legal gravity operates with mathematical precision that cannot be permanently avoided through procedural maneuvering or aggressive representation. Systematic violations generate systematic consequences when judicial authority is comprehensively exercised through established constitutional mechanisms designed to ensure equal treatment under law. No one stands above the reach of accountability when legal institutions function as designed by constitutional frameworks that guarantee equal justice under law. The seizure begins, the precedent is set, the message is clear.